Honourable Phil Goff.
Mr Speaker, this motion has two elements to it. Both are important. The first aspect of the motion is to truncate the process by which submissions can be made to the Select Committee. And I want to come back and construct the argument around why this legislation, of all legislation, should be subject to a full and proper process of democratic consideration. The second aspect of the motion is to refer the legislation, the Government Communications and Security Bureau legislation, to the Intelligence and Security Committee. And I want to suggest to the House and seek a response from the Minister, Mr Speaker, on why that is not an appropriate committee to send this legislation to. Those are the two aspects of the motion. Let me come back to the first one, which is the truncating of the period of time for submissions, because the Minister's motion states that this legislation needs to be referred back to the House on the 26th of July. It will not go through the full process of scrutiny. It will not allow people the normal time they would have to put their submissions together. It will not allow them the time that they would need to present those submissions, and I would argue that it would not allow the committee properly to analyse the submissions that are made to it. Mr Speaker, as long as I've been in this House, I've seen changes in the process of Parliament that have actually strengthened democracy. And that process was predominantly about sending all legislation to Select Committee and making sure that people had the proper time to be able to present to the Select Committee. That's how we involve the New Zealand public in the scrutiny of legislation and give them confidence that as members of democracy, their voice can be heard and will be listened to. And there's a particular reason, Mr Speaker, why we need to reinforce public confidence in that process on this particular piece of legislation. And that is because this is a particularly intrusive piece of legislation, giving very strong state powers to interfere in the lives of people, to subject them to scrutiny, to interception of their correspondence. It is something that would not normally be allowed in a free, liberal, democratic country. There may be an argument specifically why the intelligence agencies need these powers, but you therefore need to be very careful in terms of what powers you give them and what scrutiny the exercise of those powers are subject to. We know at the moment, Mr Speaker, because of a variety of reasons, the Government Communications and Security Bureau has lost a huge amount of public confidence. 40% of people in the Television 3 poll have said that they do not have trust in the Government Communications and Security Bureau. Now, I think that's bad. It's bad because we need an organisation of this nature, but because of its intrusive powers, we need to have public confidence that they are exercising their powers properly, they are subject to proper scrutiny, and that the process of giving them those powers and the process of determining the oversight is subject to the scrutiny of the public. They get this opportunity at the Select Committee, but the government has made the decision in this motion to cut back the period of time that people have to have their voices heard. Now, if ever there was a piece of legislation that you wanted to build public confidence in the process that you were operating so the government would get it right, it's this legislation. We know that what the GCSB does in its normal course of events is not subject to public scrutiny. We don't know how it operates, what it does, or most people don't know. I know, I've worked with them, but most people don't know. And they have a worry that for the first time, this organisation is being given the power explicitly to spy on New Zealanders. So you would think that the process by which we debated giving them this power would be subject to the strongest possible public scrutiny of the legislation itself, and that's not going to happen. We saw in the debate on the bill that the National Party got up and spoke for 1 or 2 minutes, didn't speak to any matter of substance, and didn't take the full call to properly debate in front of the public why this legislation was necessary. This motion itself is a motion that truncates the process of democracy, and no member of the government is getting up to their feet to defend why they're doing that. And that is wrong, Mr. Speaker. That is why we are opposing this motion. This is a process that should be particularly thorough, that should give the public the maximum input. If anything, they should have longer to do their submissions on this piece of legislation, but under this legislation they have less. So we're against the time frame that the government has set. But equally, Mr. Speaker, we're against sending this bill to the Intelligence and Security Committee.
Order.
I've sat on that committee.
Order. Standing Orders 2863 is quite specific, and in reference to the debate on the question for the motion under Standing Orders is restricted to the special powers and instructions set out on the motion. It may not extend to the principles of the bill, etc. The Select Committee motion has already been passed by the House. The motion that is under debate does not mention the specific Select Committee. So the House has already dealt with that element.
Mr. Speaker, the Select Committee that it's going to is relevant to the point of how much time that committee will have to hear the submissions. And this has been commented on earlier in this debate, but it's a particularly important point, and I want to reinforce it.
Well, I'll hear them, but it must be pertinent to,
it is pertinent, Mr. Speaker. Firstly, the Select Committee is a very small Select Committee. It only has 6 members. And the second thing is that it is unique amongst Select Committees because you can't substitute for those members. Now, I'm wondering how you're going to have the time on that Select Committee in a truncated time period to hear the submissions when that Select Committee, for example, has the Prime Minister, who's normally known to be a reasonably busy person, so he may not be available for the timing that the Select Committee needs to meet. It has the Leader of the Opposition. The Leader of the Opposition will be going up and down the country, both talking on the budget, which comes in the middle of this submission period, and campaigning in the by-election in Ikaroa Rāwhiti. So it's really difficult for the 2 key members of that Select Committee to actually be able to be there so the Select Committee can hear from the submitters in the time frame that is given. You look at the other members of the committee. One is John Banks. Well, given the court case today, he might not be available at all, Mr. Speaker, but we don't know that yet. The other person is Peter Dunn. He's the leader of a political party, and one suspects that he has a lot of things to do. The other is the Leader of the House and Minister of something or other. He's going to be busy. So it is pertinent to the question of timing. We've got a truncated period of time for the Select Committee to consider submissions, and we've got members of the Select Committee that will make it even harder for those submissions to be heard within that time frame. It is a real problem, it is a practical problem, and I don't think that the combination of those things combined will give adequate opportunity for the democratic process to be followed properly in this case. I want to reiterate the point. The timing that people have to participate in the Select Committee process is absolutely essential, given the nature of the legislation and given the confidence building period that these submissions should be involved in helping to develop, given the loss of confidence in the GCSB. This is an important piece of legislation. The opposition, the government, should be taking it seriously by taking calls on the debate. But the failure of the government in this debate to take calls will just reinforce the impression that members of the public have that this is designed to be a quick and dirty process. The government's made up its mind. It doesn't actually want to hear the submissions on it. It's limiting the time, and it's making it really difficult, actually even to put the Select Committee together to hear those submissions. There was a really important opportunity in hearing the submissions on this legislation. It was to build an understanding about why certain powers should be given to the Government Communications and Security Bureau and why strong powers should exist for oversight of that organisation. But if the public takes the message that the national government is giving it tonight, that it is not taking this process seriously, then the public will take the corresponding message from that the government is not interested in the process of democracy. They're not interested in people having adequate time to prepare their submissions and have their submissions heard, and what the public says actually won't count for anything anyway. This bill itself is wrong, and the process is a disgrace.
The Honourable David Parker.
Mr. Speaker, we in this House are the guardian of